Hello and welcome to this very special interview. Joining me today is the doyen of the Indian legal fraternity, K.K. Venugopal, one of India's most respected lawyers. Thank you very much, sir. Thank you very much for coming and talking to us here on Bloomberg TV.
Thank you.
I'm talking to you when we come to the end of a year where we've seen a whole host of very significant litigation. Let me start, sir, with one of the cases or the principles of law which hogged a lot of concern among not just Indian but global investors as well, which was the entire retrospective amendment which came through during the budget. In principle, what is your stand on this? That here was a verdict from the Supreme Court, like it, don't like it, but for a government to change the law back, not that it was done for the first time, but what is your view on this entire principle?
There is a principle of law that legal rights which are vested in a party cannot be taken away by retrospective amendments. Normally, a court would interfere with such a retrospective amendment. But in the present case, this retrospective amendment would have a direct bearing upon foreign investment, globalization, and the expectation of various institutions abroad that they would have a level playing field. To take away a judgment of the court, to neutralize it, would be a big blow to the confidence which people would normally have in a government which is functioning under a constitution which provides for the right to carry on business, the right to industrialization, globalization, and so on. Therefore, that is where I think there would be a negative effect upon foreign investment.
Do you believe, sir, that we suffered a very serious blow? Because every global investor, when one talks to, one of the things they always liked about India was the fact that it had a free and fair judicial process which worked. And somewhere, this kind of put a question mark on that itself.
No, but I don't think that so far as the judicial process is concerned, that is under
there was a belief that there is
scrutiny
here. Democracy and the judiciary works, but with the government trying to overturn an order.
See, the right of Parliament to have the final say in what the law should be has been upheld even by the Supreme Court of India, as a result of which a validating act, which necessarily has to be retrospective, which wipes away the foundation on which a judgment rested, has always been held to be constitutional and valid. Now, therefore, it is not really a question of the competence, legislative competence of Parliament to pass a law of this nature, neutralizing a judgment. It is really a question of the appropriateness of such a law when India is struggling to regain its growth and which is going to be seriously affected if our anxiety to attract foreign investment, industries, joint ventures, all that is affected by an amendment of this nature. It's not a question of the legality of it, the constitutionality of it, but the appropriateness of it. And that is a matter where the government should decide. And perhaps, most probably, they will be rethinking on the whole thing.
What could the rethinking process be, sir? For example, as you mentioned, there are already 2 or 3 cases of a similar issue pending before a few high courts. The government has made noises to suggest that, yes, we do want to rethink and we want to go back. Constitutionally, what could be the way? It will have to bring in an amendment back again when this budget session comes? Or can it issue a circular or something which
See, they have only to, suppose they have passed a validating act retrospectively. All that they have to do is to repeal it or substitute for it something which is less controversial, which is not so hurtful as it were to foreign investments and so on. Therefore, it is left to the Parliament, and it's easy to do so.
But that will have to be in the budget session.
It could
because it was a finance bill
You can pass a law at any time. A repealing law, it doesn't have to wait for a particular event. not necessarily for the budget. It can be passed at any time.
So the other judgment or the other issue which India in itself kind of grappled with this whole year pretty much through, which was a fallout of the 2G judgment and the presidential reference thereafter. The big debate was the government's right to be able to choose which way it wants to sell natural resources, auctions, etc., etc. We got a very detailed presidential reference which came through. The immediate reaction of the government was, we stand vindicated, the court has given us the right to go ahead and do what we want to. But a closer reading of that verdict pretty much said what was always the case, isn't it?
I'm not so sure as to what exactly the government was trying to achieve through the presidential reference. Now, what was said there that natural resources should only be given out by auction was not something in the nature of a binding order which would bind the government. There was nothing which prevented government, because there are so many other earlier decisions which had held that it was left to government to decide on the method by which it would farm out the natural resources of a country. For example, there was a Hindustan Antibiotics case, which is a very important judgment, where Hindustan Antibiotics, a public sector company, decided that they will nominate a Dutch company for the purpose of having a joint venture for manufacture of penicillin. Many of the drug manufacturers went to court and said, look, you didn't auction it out, you didn't give us an opportunity. Now the Supreme Court rejected it. They said that that particular company had a control over 30% of the total world market. Its product was far superior to every other penicillin which was manufactured, and therefore in selecting a joint venture partner, they do not have to auction out the entire project and ask as to who will give them the maximum return, because it is not merely a question of money which was involved. It is a question of the quality of the product, the quantity of the product, and its marketing. And therefore, this had already been laid down as a law. Therefore, there was nothing which was binding in the judgment in the 2G case. But perhaps the government may have thought that they would have been able to get the very ratio in the judgment that this should have been auctioned out. And therefore, the 122 licenses had to be set aside. Perhaps, I don't know whether they believed that they would be able to overturn that part of the judgment. But this was something which was always there.
So you've been around for 6 decades. I want to ask you a question. There is this enormous amount of litigation and a sense of fear psychosis which seems to have gripped this country. Have you ever seen something like this in 6 decades, or do you think this is... And do you agree that this is the right way forward, or would you have a different...
I do not think that there was an unnecessary fear psychosis created, because what has happened is this. In every such case, you will find that there was a wrongdoer. And the wrongdoer was a big industrialist, entrepreneur, a big politician. And what they were dealing with was not 1 crore, 2 crores, but with 100 crores, 1,000 crores, 25,000 crores even. That has happened. Look at, for example, the recent judgment in the Sahara case. There's a question of a direction to repay 24,000 crores of investors' monies. Now, therefore, in those circumstances, these so-called scams, they're of mind-boggling amounts. For all this is surfacing one after the other. And who is responsible for it? Without the government being a party to any one of these transactions, granting the 2G licenses, granting the coal allotments, and so on, this could never have happened. Therefore, it is merely because it is surfacing today, it's being discovered today, and there are persons who are public interest groups who are able to unearth these scams. That is how this is coming up. It is not that this is something which is a creation of the time or the manner in which the courts have been dealing with it. This is forced on the courts. The courts have known by choice.
So you believe the kind of, as people say, judicial activism that we are seeing is perfectly fine because somewhere the executive has failed? Are you of that view?
According to me, as I said, unless the executive had done all these things by granting licenses, etc., all this would never have happened. Therefore, the courts have to correct the illegalities which have been committed when it is brought to a notice. And lawyers, public-spirited lawyers, NGOs, they are the persons who are responsible for bringing it to the notice of the courts. They research it, they investigate it, they produce all, they use RTI, get hold of the material, then put it in an affidavit, place it before the court. And once the court sees it, it cannot possibly ignore it, and they take action. Therefore, according to me, what is being done is good. So far as this public interest the issue is concerned, the interference, the intervention by the courts, it could be overreach. In very many cases, the grievance of the person against whom the court is proceeding is that it is judicial overreach. I too would agree that in very many cases, the court has extended itself beyond the traditional conservative adjudication process for the purpose of ensuring that these persons are brought to book. But that is something which is justified. And in the history of the country today, I think it is very necessary. You have to put this down. And the courts are doing their bit in ensuring that.